Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. As you noticed, we are not in the Crime Talk studios this evening. We are out here at the Crime Talk hangar, so to speak. We've been out here, I think, a couple of times in the past. And when we've done it in the past, we've had a guest, and usually the guest would partake in a fine cigar. But unfortunately, our proposed guest, things didn't work out at the last minute. Something changed, but that's okay. We're here. You're here. We're set. We're ready to go. And yes, throughout the evening, we still have the fine cigar that we may take an occasional puff on in between questions that you all have this evening. So let's go ahead and get to it. And one of the reasons why we're out here is I actually have to fly to go see a client tomorrow. And there's a couple of things I need to take care of on the plane that I didn't get done during the day. So when we get done tonight, I'm going to do that hopefully as expeditiously as possible. And that's one of the reasons why we're here as well. So same rules apply. We'll answer all of your questions. For those of you who maybe have not joined us in the past, my name is Scott Reich. I'm a practicing criminal defense attorney, been doing it for 27 years, going on 28 years in January. Cannot believe 28 years. So when it comes to criminal law, I think I am speaking with some authority that I pretty much been there, done that, and can explain what's taking place, both what the prosecution is thinking, as well as what the defense would have to do as well. Now, obviously, we have talked extensively about the Lori Vallow, Chad Daybell matter over the last several weeks, and everything just kind of stopped. We're still waiting on Judge Boyce's ruling on the motion to continue. Pretty certain that that's going to be done. The question is how quickly will a new trial date be set? No word whatsoever as it relates to the competency of Lori Vallow. As many of you may know, she was sent back for a competency evaluation, and still waiting to see what, if anything, is wrong with her. And then we'll have to deal with that for her case when and if she is competent to proceed. In the meantime, though, the case cannot just sit and stall forever. As you may recall, last time Lori Vallow went to the state hospital to be restored to competency, it took 10 months. The state's going to have to just get for real. They're going to have to go do this case twice if that's what it means that we need to do. So I want to welcome everybody here. Let's go ahead and start taking questions. All right. First, Shelley wants to know, let's talk about the Darrell Brooks case. I got a little busy this afternoon, so I didn't get to watch the closing arguments that were supposed to have commenced this afternoon. I guess actually earlier this morning into the afternoon. But I can imagine it was a complete mess. So if you actually were able to see it, please let me know. Obviously, Darrell Brooks was representing himself for driving his car, allegedly, into the crowds of the Waukesha Christmas parade. He fired his public defenders. He wanted to proceed pro se. He started off that he was a sovereign citizen and that nobody has jurisdiction over him, and therefore he cannot be prosecuted because the state is the one bringing the party and the state doesn't exist. And basically he's like a co-equal sovereign. The sovereign citizen stuff is about as nutty as you can get. And I know that because I've represented several of those individuals over the years. But normally when the judge throws them in jail, the whole I don't have jurisdiction over you type of thing, that argument usually goes away because the judge says, oh, yes, I do. And then they get remanded into custody. And then it's no longer fun and games and the spectacle that they want to put on with the court. So Mr. Brooks, I still don't know exactly what his defense was. He really didn't have one. he was just kind of sitting there asking a couple of questions. First he was a sovereign citizen. You have no jurisdiction over me. Okay, that's a legal argument, and that went away. The next argument that they had was, I guess he was trying to say it wasn't him. But then people were like, no, you're the bad man. I saw you that day. You've maybe changed your hairstyle since then. But you are the guy that did this. And he's been thrown out of the courtroom several times. And Gen B said today he wanted to bring up jury nullification. You can't do that. Okay. And jury nullification is a way whereby the jury says, regardless of what the law is, regardless of what the facts that came out of trial are, we're going to find somebody not guilty. Okay. In my experience, only time we really saw jury nullification issues were a long time ago on small amounts of marijuana. Juries would just say, not guilty. This is stupid. Why are we doing this? And then, DA stopped prosecuting small level amounts of marijuana cases. But it's basically, you can't argue jury nullification. You have to say that the prosecution hasn't proven their case beyond a reasonable doubt. All the standard things that they teach you in law school, that there's no way that he would have been able to come up with in the short amount of time that he is had to decide to represent himself. There's just nothing that he could have done. Jury nullification can't be raised. It'll be objected to. And on top of that, the jury will be instructed that you must follow the law. And remember, just like we talked about the other night in our show, I guess it was Monday, wasn't it? The case that was sent back for the lady that was responsible for the death of two of her children, and it gets reversed because it was pretty clear. I guess it was actually Tennessee, excuse me. But there's evidence that the woman on the jury had already made up her mind, had a preconceived notion, wanted to get on the jury just to find the woman guilty. Okay. And I've got a real problem with this. We see this coming up more and more. We saw it in the Scott Peterson case. That's an issue as to whether he's going to get a new trial. We saw it in the Ghislaine Maxwell trial, where jurors are basically looking for their 15 minutes of fame and they try to get on a jury. And it's just, it's wrong. Okay. And it violates the fundamental principles of our judicial system, that you're entitled to a fair and impartial jury. And if you've already made up your mind, you have a preconceived notion of how you're going to vote without hearing any of the evidence, you're not a qualified juror. You need to be kicked off. And what really needs to happen is that people need to, what's the word I'm looking for? Yeah, people need to be held in contempt. People need to be prosecuted, because we're talking about people's lives and their freedom on something like that. And if you're not willing to give them a fair trial, you don't get it, then they don't have a fair trial. And I can tell you, when I do voir dire, I always tell everybody, say, listen, ladies and gentlemen, I'm going to sit down here in just, a couple of seconds. And so if there's something you think you need to tell me, like all of a sudden, oh, by the way, I just happen to remember I have all these non-refundable airfares tickets that are, 2 days from now. Now is the time to do it. Because if you tell it after you're seated as a juror, that's not good enough when you're sworn in. If there's anything else you think, hey, maybe I should say this, maybe I can't be fair and impartial one way or the other, you need to let me know. And every now and then you get a couple of hands, a little popcorn effect, boom, boom. Okay, maybe I have these non-refundable tickets. You're right, I can't be fair and impartial. I didn't realize it was going to take so long. I hate your tie, whatever. I don't care. Just be honest with me. And, I think jurors that get on a jury usually it's a high-profile case, and they find out that they were biased, the preconceived notions, they should be prosecuted, in my humble opinion, because it wastes everybody's time and energy. The court has to redo it. The prosecution, who's really has the burden of doing that trial over again. Okay. Try, I was talking to a victim advocate one day in court, and she was explaining how difficult it is to herd witnesses together. If your witness is homeless, bouncing around, uh, trying to find good information, good contact information to serve them, it gets difficult. The longer the event goes by to the time when the trial is, let alone 5-6 years down the road, and you have to redo it, really the only one that will benefit from that is the defense if they don't have the witnesses. Now, you can read the transcript in if you can't find these witnesses because the prior testimony has already been sworn under oath, subject to cross-examination. So the court could find there's reliability and they can have a witness read it. But it doesn't provide the same impact to a jury to do that. And, I just have a real problem with it. If jurors can't be fair and impartial, then get off the jury. Okay, here's a question. Do a giveaway, Scott, to one of your lucky subscribers, a ride in your plane into a mountain destination for dinner. All right, maybe we should think about that. It would be me, the lovely Miss Kristen, and the lucky subscriber. How's that? Let's see here. Objection, it's the tie. I've had people tell me that. And I've told jurors, like, I don't care what you do, for whatever reason, why you don't. I don't care if you just don't like me, that's fine. But it's not about me. It's about getting my client a fair trial. So that's the biggest thing. So let's see here. Don, cut live. Love seeing your hangar garage. Yes, it is the hangar, not a garage. Although it looks like it because there are several cars here. And what's the word I'm looking for? I've been told it's starting to get a little ridiculous. Yeah, what can we say? Let's see here. Okay, yes, that's right. Okay. Veronica, give that thumbs up, like, subscribe, all that good stuff that they tell you to ask people to do, because if you ask them, they'll do it. So we'll do that as well. Girl drunk last I heard Lori Vallow is still in jail. Yeah, we've been trying to monitor that. I haven't seen anything to indicate that she's actually at the state hospital yet. But once again, it's so hard because everything in the Lori Vallow Chad Daybell matter is sealed. We can't, just about every motion, every order, it has been sealed. And so it's just very, very difficult. If the court allows us to, have access to it, then maybe we're lucky enough. Is that a Malibu, Scott? Yes, it is. It is a Malibu. Capable of a maximum ceiling of 25,000 feet. Hopefully high enough to get over the mountains tomorrow. See, I want fair trial so the case doesn't come back on appeal. I agree. That's what I'm talking about, Kitty Krishner, is that it doesn't help anybody. Somebody thinks, I'm going to get in that jury, I'm going to find somebody really guilty, and I'm going to, persuade the other jurors that don't believe with me that they should come along my way. That is wrong. Okay. It just violates all the fundamental principles of our judicial system. It violates the fundamental principles of the jury process, where 12 people have not made up their mind. They've agreed. They take an oath to listen to the evidence, reserve judgment, and then follow the court's instructions, applying the facts that came in lawfully and legally in court to the law that's given. And whether you like the law or don't like the law, you got to follow it. That's the bottom line, kind of going back to the whole jury nullification. If you say, I can't be a fair and impartial juror, you're going to get kicked off. You say, hey, I trust the prosecution, everything they say. If one of their witnesses is going to be a police officer, I believe everything police officers say. My father was a police officer. My husband's a police officer. I give them the benefit of the doubt every single time. Probably not going to be on that jury, but you should disclose that if those are your feelings. If you say, I don't trust the government. Uh, they're unfair. They target people. They go after individuals of color. It's just not a fair system, and I don't want to be a part of that. Guess what? You're not going to be on that jury that day. But at least you were being truthful, okay? And I can tell you, the prosecutor, I don't think I've ever met a prosecutor that doesn't agree with what I'm saying. Is just be truthful. We'll find 12 people that can be fair and impartial. But what can you do? What can you do? Somebody's always doing it. You know, these jurors that write books afterwards, same thing. That's a problem. That's why the Scott Peterson case, where he was convicted and sent to death row for the death of his unborn child and his wife, Lacey Peterson. Here we are, 25 years later. The death penalty is off the table. And the whole issue is, was there juror misconduct? Did the juror not disclose, oh, by the way, she just happened to be a victim of domestic violence? That is the underlying allegation, obviously, in the Scott Peterson case. I don't know if there's credible evidence that was her goal, was to get on that jury. She'd already made up her mind and she wasn't truthful in disclosing it. Yeah, that's that. I'd say new trial. I really would. I know it's hard for the prosecution. It's hard for the family. But we have to do that to deter future jurors that is what is going to do. And maybe if that future juror or that juror has to pay the cost of prosecution, the cost of defense, they will think that. And let's face it, if somebody says, have you ever been convicted of a crime, if you're on a jury, that is we're not talking, I had a speeding ticket when I was in high school. I forgot about it. I didn't even think about it or whatever. We're not talking about that stuff. We're talking about something significant to the actual case. So let's see here. Pittsburgh's Best, former cigar shop owner and wine beer making store, and true aficionado of both. My husband and I enjoy the better cigars. Let's talk about it. I enjoy a good cigar too. This one, unfortunately, has gone out. Oh, well, I'll light it in a second. Follow us. I'm not sure what that is in regard to. Let's go down here, check some more stuff. Nice. Pittsburgh's best cigars. That's right. Well, Pittsburgh's Best. I've known a couple people that are former cigar store owners. I think it's kind of a tough business. You got a lot to deal with there. Inventory, traffic areas, hanging out. Gene, thanks for hanging out at the hangar. Yeah, just, we needed something a little different. Like I said, had somebody that was supposed to show up, and unfortunately it didn't work out at the last minute. So here we are anyway. Frank's here. He's been fed. We don't have to worry about the Uber guy interrupting us during our conversations with you here. Looking beyond, is that your plane? Yes. Ever have a trial going so bad that you just want to fake a heart attack to get out of it? Elbow cough. Well, Robert, good question. I don't know if I've ever told this story, but I had a case once. It was bad. Okay. The guy pled guilty, then was allowed to withdraw a guilty plea. And then his attorney got off. And this was in my younger days, so to speak. And the court said, hey, I need you to take this case. I'm like, okay, I'll take whatever. And it was a very, very bad case. The man was in a position of trust, position of authority, and was accused of doing terrible things to young men in the foster program. And, the first couple of witnesses, I got up there and I was confident. My client is innocent, just confident as you can be. But as the trial went on throughout the week, day after day, the prosecution kept calling witnesses who had never met the other witnesses, were under the care of this particular individual at different times, but yet they all had very similar stories together. And this was a case that had to go to trial. There was no offer. He had pled guilty, took the offer, somehow got his plea withdrawn, and it was just one of those cases. We're going to trial. Okay. Frankly, I prefer those the best, so to speak. And as the trial went on, it just getting beat up. I mean, just jab, 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 and you can only basically try to insinuate, what's the word I'm looking for? Liar, liar, pants on fire so many times. All these, men who are now men who are getting up there, relaying to a bunch of strangers their first sexual acts, so to speak, that was not consensual with somebody much older than them. And it wasn't good. Jurors were, tears were running down jurors' eyes. You could see jurors about day 4 or 5 just burning holes in my client, just burning holes in, with their eyes, just staring at him. Needless to say, the jury came back guilty to all counts. And since he'd already been sentenced, they already had a pre-sentence investigation report. And so we come back literally like the next day. And one of the individuals that shows up at the sentencing in this big courtroom, and Denver used to have this very historic old courthouse with tall ceilings, bad acoustics, wooden chairs from like 1920, as uncomfortable as they come. The gallery, was big and large, had these uncomfortable benches, but it's everything you think about in a courtroom. It's what you think about when you're going to law school. This is what where I want to be. This is where I'm going to make those Atticus Finch moments of, showing the world that my client is innocent kind of thing. And one of the jurors sitting there all by himself, or one of the jurors came and he was sitting there all by himself. And he was like a construction worker guy. And needless to say, client gets sentenced and we do all the formalities of appeals and blah, 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 goes. And the juror came up to me and said, hey, Mr. Reich, I'd like to shake your hand. I said, well, that's very nice. Can I ask, why? He goes, well, you were doing what you had to do, which was to represent your client. He goes, and I appreciate you doing that. He said, but I want to let you know, I was so upset when I was listening to all of that testimony come in. And he goes, I saw your client. He just kind of stared there blank. He wouldn't look at any of the witnesses. It was they come in and they told their stories. And he goes, I just got so upset. And he said he works construction. He said he would go and work at night and he would find himself just beating the nail into, the hand, just pounding it in as hard as he could because he was so upset by what he was having to hear. And he goes, but I want to thank you for what you did. I understand why you had to do it. The system works better, all that's good stuff. He said all the magic words of a good juror that got it. He goes, but I had to be here. He said, because I saw your client walk down the hall, not in shackles all week because he was in trial. And like I said, this was the old courthouse where the holding cell was down in the middle of the hallway, and they used to walk the defendants down the hallway. Now they all come out behind the magic door right there into the courtroom, for security reasons or what have you. And he goes, so I had to see your client leave here in shackles for his own peace of mind. And that was one of those cases where it was just getting beat up and just taking your lumps. And, but that's sometimes what has to happen, what has to take place so that the process can work. There wasn't any doubt that the jury was going to convict the client. The evidence was overwhelming, but he still was entitled to that process, no matter how upsetting it was. And I understand it was upsetting, those grown men talking about what had taken place. And, nobody got any joy out of talking to them about it in court, but it was the questions that had to be asked to be an effective attorney. And the jury decided, what testimony to believe. And, obviously they decided what they needed to decide. But that was one of those cases where, man, you just keep taking it day after day. So, Robert, I hope that answers your question. And that's just part of it. I always hear these cases where, attorneys are like, oh, I've never lost a case in my life. Really? Then I don't know how many trials you're doing, how many tough cases you're getting, because you got to go try the tough cases. And frankly, cases like those where, you're going in there, just like the Darrell Brooks, if he had his public defenders, they would have been in there just taking a beating all day. But they were doing what they swore an oath to do, to protect their client's constitutional rights, thereby protecting everybody else's constitutional rights. And it would have been a beating. And I'm sure the jury will find him guilty, So it's just part of being, in my experience, a good criminal defense attorney. Every now and then you got to take those cases where you're going to get your teeth kicked in, but the greater duty is to the client. Hopefully that answers your question. The judge in the Brooks case, I think she's doing a great job. She's tried to keep her cool. I think she's tried to make the appropriate record of the time. I haven't been able to watch it all, but I think she's made appropriate records as to what she was doing and why. So when Mr. Brooks had an outburst, she'd say, oh, go to the next room. And it was like a small child after a while. Okay, I'm going. And then he, was barricading himself. I think it was yesterday afternoon or maybe today with the boxes so that the camera couldn't see him. I think the judge is doing a good job. Is there something that maybe the appellate court will look at that cold, hard record and say, oh, judge, you made a legal error, didn't give him a fair trial, do over? I haven't watched it all, but what I've seen, I think the judge has done pretty well. And what a lot of criminal defendants think is that if they go pro se, they somehow are going to catch a break on appeal. Hardly. No. When you go pro se, which means you're going to represent yourself, they have different different names. Here in Colorado, it's called an arguello advisement based upon a case. If somebody wants to go pro se, you advise them that, hey, this is kind of difficult. You should probably have yourself an attorney who spent years training to do this and years of practical experience, because it's a complex area of law and you do not want to, for lack of a better term, screw yourself. And of course, the people that go pro se, I want to go pro se, I'm going to go pro se. And then they start want to file their motions, the motion to dismiss for lack of evidence. And they just don't get it. And the court has no duty to help the pro se defendant out. I think we've seen that in the Brooks case when he was trying to call certain witnesses that weren't under subpoena. They weren't on a witness list. There were certain photographs he wanted to use for cross-examination. And the judge said, nope, you're not using those because you hadn't turned them over. And also it's kind of not relevant what you want to get into it about on the cross-examination. And those are certain rules. If you don't disclose it, you don't get to use it. So the pro se defendant, I think, usually does much worse. They do not get any sympathy. Like I said, they're held to the same standard as a licensed attorney, with one exception. If a licensed attorney does a really bad job, you can always make a claim for ineffective assistance of counsel down the road and say, oh, they were terrible. But you don't get to do that when you're pro se because you're your own attorney. So you basically, I guess the good thing is Mr. Brooks takes away any post-conviction relief arguments if he loses on appeal because he has no one to blame but himself. So I guess that's one thing that came out. I mean, don't get me wrong. I think that it's not a whodunit in the Brooks case. You know, I get it. He didn't want to accept the offer. It's too much time. Fine, then go to trial. But I think it would have been much better with the public defenders for sure. But you know, hey, sometimes people just don't do that. They know better. Let's see here. Why was Morphew in court? I haven't seen anything as to why he's in court. It hasn't been 2 years yet, so his deferred judgment's not up. Was he trying to get property back? I don't know. We'll try to look up that and see what we can do. Does taking an oath mean anything anymore? Diana Jackman. You know, that's a good question. I think there's a lot of people that say that it wouldn't matter. It's a hollow oath, something along those lines. And, you know, I'm a firm believer, and I find it, I wonder what's what I'm looking for. Is it discouraging? Is it frustrating? But there's so many people that their word means nothing to them. And maybe I'm just getting old. Maybe I'm old school. But if somebody says they're going to do something or they're going to act a particular way, I take them at their word, right? I mean, I hope, you know, that they're going to do well, and then we'll go from there if they don't. But so many people just say anything these days, and their word, their integrity means nothing whatsoever. And I can tell you, as an attorney, your word does matter. When you go in on behalf of a client to talk to a district attorney, you know, do you have a reputation for being a straight shooter? Do you have a reputation for being, you know, a little evasive when it comes to, you know, stating things? Do you play by the rules? They know that. Okay. Just like we know there's district attorneys that will say, this is the best, last, and final offer, or they're open-minded. They're going to take a look at something, but their word matters. If they say, this is it, I'm not making it, then you know that's it. And if not, you can tell your client, I've known this district attorney for a long time. They're saying they're not going to make any other offer. This is it. Not, you want to go to trial. We were talking about a DA just the other day. We're like, man, we sure missed that guy. Because you knew he had looked at the case. He had been a DA for 30 years. He knew what the worth of a case was in sense of, you know, does the guy have a huge criminal history if he's a defendant? Was it a violent crime? You know, he kind of was able to sort through and do triage on cases. But you knew when he made the offer, that was the offer. It wasn't going to change. And it never changed. And you could go to your client and say, it's not going to change. This is it. So what do you want to do? Take the offer or go to trial? So I don't know. I've had people say they were going to do something, stare me right in the face, and then they go do the complete opposite. And then they act like, well, gee, why are you upset that you didn't follow your word? Oh, I don't know, but okay. You know, it's like all things in life. I can be your best friend or your worst enemy. But normally if you lie to me, we're probably going to not be friends. Okay. It's just the way it is, you know, and I don't have a lot of friends, so to speak. I have a lot of acquaintances, but friends, very few. And, you know, the two that I would consider close friends never lied to me. Always been there whenever needed something or something came up, and I've tried to reciprocate for them as well. And some people, their words mean nothing. So I think oaths mean something. They matter. They should. As an attorney, you take an oath to support and defend, the Constitution, to zealously represent your client, to play within the rules, professionalism, all that stuff. It matters. I don't think I'd ever taken an oath. Maybe I was in Boy Scouts or something. You take an oath, to be a good kid when you're young. But, I think the first time I ever took an oath was when I went into the military. Next thing you know, you're getting ready to get on a bus or something, and you're swearing to support and defend the Constitution against all enemies, foreign and domestic. You're kind of like, wow, first oath I really took that meant something. Like, this is really, this is a big deal. And so I think, you don't take that many oaths, and you don't take them to people. You take them for something, a little bit greater. So it should mean something. It should mean something. So hopefully that answers your question, Diana. Let's take a look here. Debbie Nevis wants to know from Gen B, why did Nicholas Cruz have so many attorneys representing him? It was the death penalty case. Bottom line. Obviously Nicholas Cruz is not going to get the death penalty. At least one juror said no. Life is the appropriate option, and so be it. But when there's a death penalty case, and in the Nicholas Cruz case, he did not go to trial because he pled guilty. And that was kind of a mitigation attempt, thinking, okay, maybe if he pleads guilty, then they should, not go death, because look, he's already accepted some responsibility for that, which was not a bad move. Obviously, it worked for the defendant, and the advice of his attorneys, which was to plead guilty. Let's just go to the sentencing phase. They put on their mitigation case. And I know there were lots of people there at the table. Some of them could have been, investigators, social workers, paralegals. I don't know if they were all attorneys, but when you have a death penalty case, you're going to have, at least two trial attorneys, at least an appellate attorney, an investigator or two, usually have a mitigation expert that's there. If not more than one, maybe an expert or two listening to testimony so they can rebut it or, refute anything that was said. So that's why that generally happens. I can tell you, normally in a death penalty case, and I've only done one, at least start out that way, we had two trial attorneys. Ours was early enough. We had appellate counsel kind of on standby, but we had an investigator, and we did a lot of the early initial, mitigation in that case. But it is a team effort. I used to think, when you're younger, I'm going to trial, I'm going to do it all myself. Maybe I'm just getting old, but I like to have, at least one associate with me, if not a paralegal back there. And even, an IT guy. We did a case down in Lamar. It was two attorneys. I don't think we took a paralegal, but we took Frank because there was lots of technical issues, lots of sound bites that we needed to take and to edit. And he put together this incredible montage for our closing. And it was a case of the gun just went off. And, we had the expert testify to it. And we had all these body cam videos of my guy. Before anybody's asking his questions, he's literally just like, it just went off. And Frank he took all these different bites. It just went off. It just went off. It just went off. And that's something that there was no way that I could have done that on the fly to do that. I mean, it was a full-time, it was I think an all-night endeavor for him to do that. But it was something that kind of developed kind of throughout the week, I think, as we did it. So trials are tough. They're demanding. You start at, say 8:30, 9 o'clock, but you're usually up by 5:36, getting ready for that particular day, tweaking things, whether it's, voir dire, opening statement, witnesses that you expect to come next, questions you want to ask based upon the testimony that's come out or didn't come out. You have to change your tactics. I usually find when I do a trial, I usually get sick afterwards, like a cold, just because you just get so exhausted from it. But it's long days. I mean, it's usually, like I said, you're up at 5:36 in the morning. You're probably still you come home, take a break, or stay at the office, get something to eat, go through it all and go back and do it again. But you're working about it. You're thinking about it the entire time. And I almost prefer to go do cases on the road just because you don't have the distractions of the office where you can go back to. I try not to go back to the office during trial. I try to tell my clients, I'm unavailable, I'm in trial. And when your trial's up, then you'll get my undivided attention as well. So let's see here. Next question. Oops, hit it again. Penny, if the Lori Vallow and Chad Daybell, if their orders are all sealed, does that mean that you can't talk about it anymore? Well, the court has sealed those, and so obviously we don't have access to them. Now, of course, if they were to leak to the public, we could talk about it, but I'm not aware of anything that's leaked. The attorneys are basically under a gag order, so they can't talk about it. It's really what was helpful is when they do allow motions that have been filed to be released to the public, you can glean a lot from those motions. That's where the good stuff comes from. And no disrespect to, some reporters out there, but when there were a lot of motions filed in the Chad Daybell matter, there was a general report, kind of news reports. Oh, they filed this, and this. But when you read into it, particularly as related to the motion for Chad Daybell on the motion to sever, he was telling the world through his attorney that he was going to throw Lori Vallow under the bus. He's saying, we have inconsistent theory of defenses, Judge. I'm going to be pointing the finger at her. If we're in trial, she may be pointing the finger at me, but I'm telling you, I'm pointing the finger at her, saying that she did it along with her brother. Now, Chad Daybell, through his attorney, had to make those statements to get to the level so the motion for severance can be granted. John Pryor had previously moved for severance, and it was a very generic motion. I was like, are you kidding me? I think, as I recall, I think I even commented like, this is a generic motion saying, oh, we have inconsistent theory of defenses. That's it. I said at the time that wasn't going to be sufficient, and it bore out because he filed a new motion saying, listen, Judge, we're going to blame Alex Cox, Lori Vallow, and he referred to, Lori Vallow Daybell as Lori Vallow throughout the entire time, which I have done. Some people said, why don't you call her by her married name? Well, that's a little hinky in and of itself, but I was like, oh, they're going to be separated by the time they get through this. Nobody's filed for divorce just yet, but that's one of those things where if I was his counsel, I'd say, listen, man, it's over. Okay? One or both of you are never going to be together again. Let's just cut to the chase. You need to let her go. And it would look better to say, listen, I was duped by her if you file for divorce. Heck, the longer you stay married, the more likely she's going to, she could get something out of your estate, no matter how small or however gone it is, since I think he signed over his house to the attorney, Mr. Pryor, which brings me to another thing. Is I do not know how he intends to fund this case. And if, Mr. Pryor has any intention of getting off because he hasn't received payment, Now is his time to do that so that he can get court-appointed counsel at no expense for sure. New here. Here's your question and what you think about the death penalty. You know, lots of people have lots of different positions on the death penalty. Okay. I said I had a client that they wanted to, send him to the death chamber, lethal inject him. Didn't turn out that way. Whether I supported it or didn't support the death penalty, it doesn't matter. My oath and obligation was to that client to make sure that due process was given and that it wasn't done. There's lots of good arguments for and against the death penalty. Okay. Obviously, if you've heard me, when I sometimes vent a little bit, I'm very much for words have meanings, right? Like we talked about, when people give their word, it means something. You need to follow through on your word. Well, words have meaning as well. And so when you look at the Constitution, clearly, when it was written, when it was drafted, the death penalty was just fine. And obviously, you can't have cruel and unusual punishment, but the founding fathers still believed that there were circumstances that warranted the death penalty. Now, obviously, I think we'd like to say we've become a little more civilized over the years. We don't draw and quarter people. Not that we ever did in the United States, but the king would do that. We said, hey, we're gonna make this as painless as possible. We're not going to torture you. The Nicholas Cruz case. Look at that. Some people would say that if somebody has committed one murder, then maybe they should face the death penalty. And normally that's not going to happen because through the years, the Supreme Court and states have adopted aggravating and mitigating factors that would warrant the death penalty. So they're not going to just hand it out to anybody. Basically, you got to become some of the worst to get it. But like the Nicholas Cruz case, one juror said life was appropriate. 11 other jurors apparently said death was appropriate. But it has to be unanimous. So the jury has spoken. The matter is resolved. It's done. It's over. But at what point should people get a volume discount for crime? Right? I've been in front of many a judge that says, I do not do concurrent sentencing, which means sentences should run together. So if you have a client that gets out and commits burglary A, then he does burglary C and burglary B, he committed 3 crimes. He could face the possible penalties consecutively. Let's say there's a range of, say, 4 to 12 years for the 3 burglaries. He could get up to 12 years for A, 12 years for B, 12 years for C. That would be a legal sentence. The judge can say, I'm going to give you 36 years. Don't break into people's homes. Do you think that would deter him? Probably when he gets out and he's an old man. You betcha. Would that maybe deter others, which is one of the principles of sentencing, that, to deter the defendant from committing crime again, as well as those who know about his crime and punishment? Probably, maybe somebody would think about that and say, you know what? I knew a guy who got 36 years. Judge didn't really like burglaries. I think I'll pass. I'll sit here in the car, guys. Right? So like Nicholas Cruz, 17 deaths. That, like I said, it wasn't a whodunit. He did it. He admitted to it. Then he said he was sorry. So he gets the same punishment for all of those cases. Okay, he's going to serve 17 life sentences. Okay, fine. Really? Is he ever going to serve more than one? No, not really at all. So he's going to serve, he gets a volume discount for crime. And that's the way a lot of people look at it. At what point do you just have to say enough is enough? And that's not it. I had a federal judge once tell me that, there's usually something you can say nice about a client. And I can probably think of maybe one or two times where you're just thinking, "Ooh, it's going to be tough. It's going to be tough." Like he's always been nice to me. Nope, can't say that. He's been respectful of the court. Nope, I haven't. Judge, he's always shown up to the court in time because he's been escorted by these fine deputy sheriffs over here, or U.S. Marshals. There's some people that just cannot function in the community. Okay. But we're a country of laws. And so you just can't go around getting rid of people. They just can't disappear, so to speak. That's what they do in third world countries when the dictator doesn't like you and the secret police show up and they just do that. So I don't know. Like I said, I've met pure evil, and I mean that, pure evil, on a couple of occasions. And you just think, man, this dude is scary. And I'm usually not intimidated or, scared in any way, but they just give you that weird feeling like, ooh, this is not good. And, like when the hairs on the back of your neck stand up because they just kind of creep you out. We had a client once where I had a female associate that went with me for kind of the first visit, accused of terrible, terrible things. And she was literally like, can't be here. Cannot represent that guy. He's just too scary. And I get it. I'm not going to say, okay, no, you must go back or anything along those lines. But it just, there is such a thing out there called pure evil. And what do you do with it? And at what point does it, the state legislatures can pass whether they want a death penalty or not. The legislature did away with the death penalty here in Colorado, I think 2 years ago. The federal system still has it. And, when a heinous crime is committed in a state that doesn't have the death penalty, the feds will usually try to pick it up and proceed that way. Look at the guy, his name escapes me, that went into that church in South Carolina. They befriended him, they offered him food, and then he winds up, doing terrible things. He got sentenced to death in the federal case. Like I said, what do you do with a guy like that? What do you do with a guy with a Nicholas Cruz? Maybe down the road, they are going to teach classes in prison and, redeem themselves. I guess all people are redeemable. I mean, I think if I did something terrible, I'd be redeemable. But there's some people, and we all know that there are some people that no matter what you do, no matter what they do, they will always be evil. And I know that probably sounds terrible and bad coming from a criminal defense attorney, but we like to speak the truth here. Okay. So the question about the death penalty, it's there. Some states have it, some don't. I'm a big fan of the plain meaning of the words. It was written. It's there. I've seen lots of cases where it is and was a great bargaining tool, where the prosecution says, if your client pleads guilty, agrees to go to prison for the rest of their life, we'll take death penalty off the table. And now somebody's charged with homicide. They do terrible, bad things to people, whether it be one person, 5, 10, 15, 17, they get to have a, multi-week trial, enjoy it, become famous. Look at the Dahmer stuff, right? He has a fan club when he's in custody. I mean, a lot of these guys do it for the notoriety, right? So I don't know. It's tough. It's an individual thing. Like I said, I've never been on a jury, but that's one I probably wouldn't want to be on. But, I was talking to a prosecutor today who, was a pilot in the war. And, he could tell you in a heartbeat whether somebody, deserves something like that, because he's had to make that decision. He's dropped those bombs. It just, here we are. So I know that was a bit of a tap dancing Charmaine Hunter about that, but it's just something I guess deep down, it's a good thing to have as a bargaining tool. It shouldn't be done except for the worst of the worst cases, and it needs to be dealt out fairly. And what I mean by that is, if you look at the Aurora Theater shooting case, Mr. Holmes, I think it was 12 people died in that particular incident. Mental health issues, but, white kid, guess what? No death penalty. Nicholas Cruz, white kid, maybe Hispanic kid, but guess what? No death penalty. Then you go down, you look at a lot of people on death row in certain states, and they are all of African-American descent. Some people could argue, maybe one murder, they get the death penalty, but these people that do 12 and 17, really, I know they're different jurisdictions, different cases, different juries, and they can decide that. That's ultimately up to each case. But I think some people have to start looking at that and saying, wow, is that really, really fair? So you either kind of have to do it to be fair, I guess. If you knowingly kill somebody under a first-degree murder statute, then death should be the punishment. I think most people agree, maybe there's some redeeming quality. Maybe didn't really mean it. It's heat of the moment, blah, blah, blah. But if one guy gets it for one murder and guy that doesn't get it for 17, I think a lot of people are going to cry foul and say, hey, that's not very, very fair at all. So we'll have to wait and see. Okay. So the Barry Morphew, Trish or Debbie says, motion to return his belongings they took from evidence. Now, one thing we need to think about here, ladies and gentlemen. Now, in the Barry Morphew case, as you may recall, when the district attorney, I believe her name is Miss Stanley, dismissed that case, she said that we're dismissing it without prejudice. We're still looking for the remains of Suzanne Morphew because we believe she's deceased. We believe that we know where it is. We just need to, where she is. We just need to wait for the snow to melt where we believe the body will be found. And I brought this up over the summer. All right. The snow melt is gone up there in the mountains. Where's the district attorney? Have they been able to find anything? No, nothing. Here we are, October 25th. It's getting cold. There's been snow in the mountains, and yet no charges have been refiled. No remains have been found. And so, I don't know. Just have to wait and see. So I would expect he'll get his property back, and it is what it is. I don't think they're ever going to file it short of somebody saying that. Donna wants to know, can YouTube creators state person is guilty of murder or whatever crime if they have not been found guilty? Can they be sued for defamation? The answer would be yes, and potentially yes. Now, if you notice, when I talk about cases, I say like, I hope, I believe that Mr. Brooks will be found guilty based upon the evidence that I've seen. But we always qualify in cases that we give everybody the presumption of innocence. These are mere allegations. You say the good old allegedly. But remember, for defamation, I can have an opinion. I can have an opinion that somebody did something, and that's not defamation. Defamation is that you make a knowingly false statement and you publish it to the world. Most of the people that get charged, probable cause has been found. So you have a good faith basis for the opinion that you state. But I think I would still, out of fundamental fairness to everybody involved, let them know that the presumption of innocence remains, and they are presumed innocent unless and until a jury finds them guilty beyond a reasonable doubt, or they plead guilty in a court of law. So hopefully that answers your question. Let's see. Leslie. Scott, what are your thoughts on workforce unions? Do they cause more harm than good, in your opinion? I read it because it was a super chat. Leslie, I have no opinion on workforce unions. My experience is if you go political, you're going to upset at least 50% of the people that you are speaking with. Yeah. Let's see. I'm not following, just explaining to me. I'm not getting anything of this. All right, Kathy Baumgartner, not exactly sure what you're talking about, but this is a show where we take the questions if we don't have a particular comment here. Gene. Was Strawberry Shortcake and the other juror already prejudiced against Scott Peterson going into the trial, in my opinion? I tend to think the evidence would tend to go that way, and we'll have to wait and see. Scott, will Chad be divorcing Lori? Do not know for sure, but I think I'd certainly bring it up to him if I was his attorney, saying, man, let's get this. Lauren, how long will jury deliberations in the Brooke case take? They have a lot of counts to go through, but I'd give them a day, maybe less. I mean, it's not a whodunit. We'll see. You never know. Jury can take as much or as little time as they need. Yes, Kathy, I am jumping from case to case. Now, if you had looked at other shows, we focus on one particular case. Tonight is kind of like an open talk as it relates to this. So sorry. Lori, what is the most challenging, interesting publicly case you've had either involved in or pulled your interest so much that you still think about it? It would be the case over in Montrose, Colorado, which resulted in the death of 2 young children. Even to this date, nobody can say with any certainty what the cause of death was. The group was involved in some sort of doomsday theory type of apocalyptic thing. The world was coming to an end. And there was one witness who I think the judge even found was not very credible, but the prosecution did and said, oh, it must have been starvation. But because only the remains were found, there wasn't anything there. And, the mother of the child, my humble opinion, is the one responsible for the death of those 2 children. Although our client was one of many that was prosecuted, he got the lowest sentence. But that case still bugs me. It bothers me. When should somebody be held responsible for child abuse? Here in Colorado, the child abuse statute basically says if you are caring for a child, you could be held responsible. And there's a really bad case, and I can't remember the name of it, but it basically said that the facts were a man was beating his child. The stepmom knew about it. Kid had some pretty severe injuries. Mom was charged. They said, hey, that's sufficient under the statute. You should have basically intervened. Well, if it's not your child and you don't know what's taking place, because let's say, for example, you're on one end of the property and the people that are doing other harms are on the other end of the property, and you don't interact and you don't see them, other than you're in a bigger group together, although you're separated in the macro, how can you be held responsible for what somebody else did or failed to do? And, they relied upon that case. Well, they were together. They must have known. They should have known. Well, it's like, okay, what about the case where kids getting abused? Where are the neighbors? Charge the whole neighborhood. Charge the police force for not intervening. The old takes a village. You want to play that game? Then let's go there. But don't do it just because you don't like a particular defendant. But that was the case that bugged me. We did it. God, I can't believe it. It's been like 4 years now. Can't believe it's gone by so fast. Yeah. I had another one recently. I mentioned it last week where it was a homicide trial, not guilty on first-degree murder after deliberation, but they were found guilty of second-degree murder. And the judge refused to give several instructions that we offered to the court. We believe we had a good faith basis. You only have to present a scintilla of evidence. And yes, that's right. The case came back, reversed. Why? Because the judge did not give the instruction. And it's funny because I was thinking about haven't heard anything. What's going to come up with that case? So we get a do-over on that one. So I've been thinking about that one a lot lately, just because, there's cases that you lose that just bug you. Cases that I've won never bug me. The ones I lose are the ones that gnaw on me for a long, long time. Judith, I'm sorry. I'm trying to take as many questions as I can, but they go by as fast. Grizzly, can you explain hearsay? Yes. Under the rules of evidence, Rule 801, hearsay. Hearsay is inadmissible. And then they have all the exceptions. But basically, when somebody goes to court, the person who testifies can only testify as to what they saw, what they heard, or what they did. They cannot testify as to what someone else said. So if you have a witness that comes to court, that's all they can do. This is what I did. I arrived on the scene. I saw this. I did this. If there were other people there and that person had a conversation with those other people, other than maybe the defendant, because there would be an admission by a party opponent, the witness on the witness stand testifying to what somebody else said or did is hearsay. That's the easiest way to remember it. So if somebody's on the witness stand and they're going to testify as to what somebody else said, objection, Your Honor, hearsay. There are a slew of exceptions to the hearsay rule, but that is the general rule. Most judges like to keep it simple. Don't get into multiple layers of hearsay, that witness said, well, I talked to Joe, who said that he spoke with Susie, who said that Jane said this. And you got multiple layers of hearsay, completely inadmissible. So hopefully that explains hearsay to you. You want to hear from the person that actually saw it, that actually did it, because that has to be subject to cross-examination. And if somebody is testifying to what somebody else testified to, you can't cross-examine that other person. And so it goes to reliability of the statements that were made. Let's see here, a couple of questions. Kitty wants to know, realistically, how long should a death penalty trial take? Start to finish. Obviously, it depends on how complicated the scenario is and how many victims there are. If it's one or two victims, I've seen cases related to homicides A good homicide case doesn't really last that long. It's usually a week at most, maybe 2 weeks, 7 days. You got to keep it concise. You got to keep it moving. Otherwise, the jurors get bored. And bored jurors distract. You got to keep them focused. So you got to keep it as succinct as possible. Judges demand that of everybody. But a good homicide case, we're talking 4 to 5 days seating a jury. A death penalty case takes much longer to seat the jury because you have to death qualify them, which means you can only have jurors that say, I would consider the death penalty if it was an option, which it is if they're qualifying for death. It seems a little weird that you're trying to find jurors to talk about the punishment when they haven't heard the facts of the case. But one of the requirements is that they have to be able to follow the law. And follow the law is that they will consider the death penalty. Now, if the juror says, I'll consider it, but I don't know if I could do it, they're probably not qualified. Most prosecutors don't go forward on a death penalty case unless their case is very rock solid case. So I said, figure a little longer time to qualify the jury to make sure they're death qualified. You present the evidence, depending on how long the facts are. Let's say a week for a jury, a week or two to present evidence. And then if there's a conviction, then they roll straight into the mitigation phase. I would figure another 2 to 3 days. You read old cases where the death penalty was imposed. You go back and find old cases, from the 40s, 50s, 60s. Trial was done in 3 days, and death. There you go. Let's see. Lula, Scott, has anyone ever successfully represented a sovereign citizen? Well, I'm sure they've represented them, and things have worked out. Usually people come around, so to speak, when they're like, I don't believe in it that much. Like, I want to go to prison for it. I was just, kind of in the moment. I'm really sorry. And they kind of snap out of it. But I'm not aware of a circumstance where a sovereign citizen has won the case. Maybe if there were sovereign citizens on the jury, maybe all of them. I don't know. Gene, yes, To Kill a Mockingbird. Greatest book ever. Frankly, the movie's even better. Lamona. I was a juror on a double murder trial in Las Vegas in the early 2000s. I just got another jury summons early November to appear. What do I need to bring to court to get excused? I'm having back surgery on October 31st. My advice, Lamona, is I would call the jury commissioner. There should be a number on there, and you can ask to reschedule for a time that is more convenient. They normally give somebody a pass. That's just the way it is. If you can say, hey, I need this. If not, take a note from your doctor. Say, hey, the person can't stand too long, what have you. Normally, they try to accommodate people in that situation. Nobody wants a juror in pain to do something like that. Jamie, live Tuesdays can be a little strange to follow. Yeah, it's kind of free flowing, that's for sure, because we're answering questions, which means we jump around. Yes, we do. Scott, love listening to Scott reminisce. Sorry, no PC tonight. So hard to chat. So hi all. Let's see. Girl drink drunk. Scott, I think it's possible that Tammy Daybell was poisoned with digitalis, if I'm pronouncing that correctly. As an RN, I know the drug can cause the heart block, which causes blood to be backed up in the pulmonary artery. Good. I mean, question is, I don't know. We've never seen the autopsy report, so we do not know what it is. Okay, Sherry, I have a silly traffic ticket question. Well, go ahead and send it in here. Let's see here. Pittsburgh Best. This one, yeah, it went out and I haven't relit it, but it is a Monte Cristo classic series cigar here. But let me just tell you, I know we digress and some people don't want to hear this, but I went to my quarterly cigar dinner that I get to attend. And it's always, I try not to miss it. It's always fun. But I had one of the best cigars that I ever had. And the guy that was the cigar guy there that night brought them, and they were amazing. And they were Macanudo Montego y Cia. Anyway, and unlike this cigar that has a little paper band, this one had a metal band around it. And it was one of the most smoothest cigars I've ever had in my life. It was amazing. So there's good cigars, there's bad cigars. We like the good cigars because, as I've told the lovely Miss Kristen, good cigars don't smell. Ms. Johnson, hey Scott, how'd you meet the lovely Miss Kristen? Oh, that story, I don't have enough time tonight. We're running out of it, but we can do that some other time. Maybe we'll do that on our Patreon show. Alma, did you watch the ruling on the gag order in the Stockton serial killer today? Do you think the defense attorney had a chance at that argument? Haven't seen it, didn't know. Sounds like it didn't go well. But once again, the gag orders, the attorneys can't comment on the case. They can't hold press conferences and say, oh, let me tell you what this, I was going to show, blah, blah, blah. I'm okay with that. What I don't like is when they seal the cases like they do in Lori Vallow, Chad Daybell, that we cannot see what's going on. That's the part that bugs me. Don't the tough cases hone your skills as an attorney? Yes, because you get to try things that you normally wouldn't do. What have you got to lose? You go for it. You throw it out there. It's like that Hail Mary pass down the field sometime. Going back to the Mr. Brooks case, the judge has a lot more patience than I do. I would have had that ankle bracelet and zap him several times. She doesn't want to a do-over. This is very taxing. No, I think the judge is doing her best. My hat's off to him. Difficult clients come around. It's just the nature of the beast. Lots of people that they get sideways with the court like that usually have mental health issues, or they just don't care. Usually it's kind of a mental health thing. It's just kind of sad because it's working against them. But a good judge will maintain that good judicial temperament, treat the person with dignity and respect as the best they can, and maintain the dignity and the decorum of the courtroom. We'll just have to, see if they can make it. She probably goes home and has a nice big tall glass of wine or a stiff drink at the end of the day dealing with Mr. Brooks. But, it's easier just to get through it than it is to delay it. And just, you're going to get the same nonsense. So you might as well go. Cat, my word means a lot to me, I guess, because I'm old. But if I take an oath to swear on the Bible that I will do something, then I will do it. Yep. I agree. That's always the thing. You always think courtrooms always have to swear on the Bible. Only one courtroom in my entire criminal history I've ever seen a Bible, and that was in federal court in South Carolina. They even had a little stand just for the Bible. Only place I've ever seen it. You don't take an oath when you go to court do you swear, on the Bible, the what you're going to tell the truth, the whole truth, nothing but the truth, so help you God. They don't do that. It's, do you swear under the pains and penalty of perjury to tell the truth, the whole truth, and nothing but the truth? Yes, I do. That's what the oath is these days. I always think that's interesting because on TV they still, not so much anymore. They put the Bible there, but obviously for a long time that was it. But I've only ever seen one Bible in a courtroom. That was in federal court in Charleston, South Carolina. Most beautiful courtroom I think I've ever been in. Just absolutely gorgeous. That's why I love going to federal court. It's just so good. If Scott Peterson's death sentence is overturned, will be put back in general population? It has been overturned. The prosecution said they would not seek the death penalty again. So yeah. Wow, you look at that. It is already 7:30. We went long tonight, didn't we? Scott, Iris I-10 argued to get Barry Morphew's evidence back, and I read it was denied. Okay. I'm not exactly sure what evidence they were trying to get back, so I don't know. But yes, I'm sure it's some sort of personal property. He would like to have it back. And, let's go to court. The prosecution probably argued that it was still something of evidentiary value. Their investigation is ongoing. And in that case, they can keep it. The court will probably keep that, keep the evidence then. Scott, do you think today's ruling on the Pike County massacre to allow video and audio effective immediately could be a possibility for the Daybell debacle down the road? Yeah, and the Pike massacre, that was weird. Or they were going to allow video coverage, but then like the witness could decide whether they wanted to be on camera or not. That made no sense to me, but whatever. And if the judge changed their mind, that's good. Just allow it. It's a public courtroom. Things change over time. Most people don't have the time to drive down to the local courthouse, go through security, find a courtroom where a trial has begun to sit down there and watch it. Oh, yeah, that's right. Work and maintain their life. Like I said, I've said this before. I would put cameras in every courtroom. They should be on. What's the best way for us to see how judges are performing? What's the best way to see how the prosecution is performing? Are they prepared? Are they making reasonable offers? Are the judges treating people with dignity and respect? Heck, are the defense attorneys doing what they're supposed to be doing? Are they showing up on time? Are they prepared? Absolutely. Nothing. If anything, people will be better when they go if it's being televised. I swear I've seen things done that it was done because basically nobody was watching, so to speak. Oh, what are you gonna do? Appeal me? Yeah, I guess I will. Okay. And that's the thing. Man, a lot of questions tonight. But guess what? If you'd like to have those answered and you didn't get them done, guess what you need to do? Come join us on our Patreon show that we're going to do in just a few minutes here. Thank everybody for watching. Thanks for doing our Tuesday night live with us. I know it wasn't our normal setting, but hey, things change. We change it up a little bit. And I want to appreciate everyone for being here. Great questions. And hey, hopefully come join us on our Patreon show here in about 5 minutes. Have a wonderful night. We'll see you next time on Crime Talk.